a lot of people don't. Like, they get upset when they get called to jury duty, or they're like, I have a life.
It's a great opportunity to learn about how the court system works. When I was on jury duty, the judges made themselves available to us to answer questions. It was just a very interesting experience altogether.
I just thought the whole process was fascinating and a really good experience, a good life and learning experience.
I believe it's important to answer the call to jury duty because you can bring together a diverse group of people with varying views so that they can judge the defendant without bias.
It's important to be a juror and to uphold the judicial system that someone is innocent until proven guilty.
It goes back to your civic duty. If everybody participates, then it's not a burden on one segment of the population. If everybody does it, everybody takes their turn, that's how the system works, and it works better that way.
It's our duty as Americans. We have a justice system that allows us to participate, and I think that it's important that we do that in order to preserve that system.
I'm Ohio Supreme Court Chief Justice Maureen O'Connor. On behalf of the court, thank you for devoting the time away from work, school, or family to answer the call to jury service. We are privileged to live in a country where our state and federal constitutions guarantee the right to a trial by a jury of our peers. This video will provide you with some information you need to help you in this important job, including what to expect as a juror and an overview of Ohio's court system. I hope that you will enjoy this opportunity to play a key role in our system of fair and impartial justice. The people involved in the case on which you may be selected as a juror are depending on you.
Ohio's state courts are divided into 3 levels: trial courts, appellate courts, and the state Supreme Court. Trial courts consist of municipal, county, and common pleas courts. Municipal and county courts have limited jurisdiction to hear civil cases for disputes under $15,000 and criminal cases involving misdemeanor offenses such as impaired driving, assault, and domestic violence. They can hold preliminary hearings in felony cases to determine whether probable and reasonable cause exists to hold the defendant. If there is cause to go forward with the case, it's transferred to the common pleas court. A common pleas court hears cases for things like divorce, child custody, and juvenile and adult criminal matters, as well as civil matters. The state's 12 appeals courts hear appeals from the trial courts in both civil and criminal matters. The Supreme Court of Ohio is the state's highest appellate court. It decides all state constitutional questions and cases involving questions of public or general interest. It also hears appeals from the Board of Tax Appeals and the Public Utilities Commission of Ohio. The Supreme Court also hears all appeals involving criminal cases where a death penalty has been imposed. A jury trial is a fundamental right available to everyone and is a treasured part of our legal system. The types of cases heard in jury trials can be criminal or civil. In a criminal trial, the person accused is called the defendant. 12 people are chosen for a jury trial in common pleas court, 8 people for municipal court jury trials. In all criminal matters, the jury has to reach a unanimous decision to find the defendant guilty or not guilty. Civil trials involve disputes between individuals or organizations brought to court by the party called the plaintiff against the party being sued called the defendant. The cases can include contract disputes and personal injury lawsuits. There is an 8-member jury for a civil trial, and at least 6 must agree to the decision. There are 3 stages for jurors: selection, the trial, when statements and evidence and arguments are presented, and the deliberations to make a decision. First, let's meet the participants in a trial. There's the judge who presides over the trial, a court official in charge of keeping all the documents, records, and physical evidence for the trial and organizing the jurors, the bailiff who maintains courtroom order and ensures the safety of the trial participants, including jurors. A record is made of everything that is said or done in the trial, either by a court reporter or by audio-video recording. The attorneys present the evidence for the plaintiff and the defendant in the trial. There are many different terms you might hear in a courtroom. One of them is voir dire. This comes from Old French for to speak the truth. It's the process when potential jurors are questioned by either the judge or a lawyer to determine their suitability for jury service. These questions are not meant to pry into your personal affairs, but to learn if you have any knowledge of the case, a preconceived opinion, or if you've had any experience that might make it difficult to make a decision in a completely fair and unbiased manner. The attorney for each side may challenge a prospective juror for cause, that's concern that the juror may not be impartial, and preemptory, meaning no cause needed, but it cannot be based on race or gender. The idea is to ensure that a fair and impartial jury is selected. If you're selected for the jury, you'll be asked to swear or affirm that you will follow the law. The judge may also select alternate jurors in case a juror becomes sick or can't see the trial through to the end of the process. The courtroom drama portrayed on TV shows and movies is not reality. It's important to set aside any preconceived ideas and see how the judicial process really works. After the jury is selected, each side of the case may present opening statements presenting key points that they plan to make during the trial. The plaintiff will then present evidence first. Evidence is the testimony given by a witness under oath, exhibits, and facts that the lawyers have agreed to and the court requires you to accept. Some judges let jurors take notes during the testimony, others do not, so make sure you're aware of what is permitted. After the plaintiff, the defendant has an opportunity to present evidence, and then the plaintiff may decide to offer additional evidence to explain or disprove the defendant's evidence. The judge is responsible for admitting evidence. You're responsible for deciding what is to be believed or how much weight to give it. Witnesses need not be believed simply because they are under oath. It's up to you as a juror to evaluate testimony. If the judge excludes evidence that has been heard, you will be instructed to disregard it. You'll have an opportunity to hear each side in the case give their closing arguments, in which they will tell you what they think the evidence has shown. Their arguments are not evidence, however, and should not be relied on as such when you're deliberating. The judge will instruct you on the questions of fact that will be decided and the law that should be applied to the evidence presented. After the final instructions, you'll go into the jury room to deliberate, decide the facts based on the evidence presented, and apply the law as instructed by the judge. Before you begin, you'll elect a foreperson to help you conduct your deliberations in an orderly manner and so that everyone can express their opinions. This person does not have any greater power, nor does that person's vote have any more importance than others. Civil cases require a vote of at least 3/4 of the jury to reach a verdict. In a criminal trial, the jury must find the defendant guilty or not guilty by a unanimous vote. The verdict is announced in court. To ensure that a trial is conducted in a fair and impartial way, there are several things that you must remember while serving on a jury. You may not talk about the case with your family or friends during the trial. You may not discuss this case with your fellow jurors outside of the deliberations. Do not use social media such as Facebook, Twitter, or YouTube to discuss the case. Do not research the issues or laws on the internet or watch or read news coverage of the trial. Jurors who conduct their own outside research during a trial or who talk or blog about the case while the trial is still going on can face financial penalties or other unpleasant consequences. So please make sure that you follow the judge's orders and don't communicate with others about the case until the trial is finished. Keep an open mind. Do not decide before all the evidence and arguments are heard and you receive the instructions on the law. Some notes about general courtroom behavior. Please stand when the judge enters. Do not talk, read, or use electronic devices when you're in the courtroom. Be attentive. Arrive every day and on time. Court cannot begin until everyone is present. If you have any questions, please do not hesitate to ask the bailiff or other members of the court staff. If you are seated on a jury, you will be teamed with people of many diverse backgrounds. The strength of our jury system springs from this variety of perspectives. You may disagree with one another, but there's no room for disrespect among jurors. You may decide issues that affect the life of someone very different from you. Your decision must be based upon the facts of the case and the law as it was given to you by the judge. It's everything you need for your decision to be fair and impartial.
Jury service is an important civic duty. It is direct citizen participation in government. Your efforts today help preserve the constitutional right we all share to receive a fair trial by a jury comprised of fellow citizens. Thank you for your service.